Hi, and thanks for coming to Courtroom Mediation. I want to talk to you about mediation and negotiation. Let's say you've decided you want to go to mediation. Great. Every mediation necessarily includes a negotiation. So we need to understand our negotiation process. The first step in any negotiation process is identifying what it is that you want. Let's use an example of a typical personal injury case. In every personal injury case, the plaintiff has four objective interests that they're looking at. The first one would be the identification of the costs. In these cases, traditionally, the plaintiff's attorney will advance the costs for the client. The attorney is not a banker, the attorney is an advocate, so that money needs to be paid back to the lawyer. But we need to identify how much it is. Second, we need to identify the medical bills that are involved in the case. Have those medical bills been paid for by someone else, or are they unpaid? If they've been paid for by someone else, who is it? A health insurance provider, Medi-Cal, Medicare, Medicaid, perhaps workers' comp. Whoever it is, we need to identify who it is and how much we have to reimburse them. The third one is the net recovery to the client, or an amount that Judge Kennedy used to tell me. He would call it radio station WNIFM. What's in it for me? And that's something typical of every plaintiff's case in item number 3, the net recovery to the client. Item number 4 is the attorney's fees. Once we figure out items 1 through 3, we can always figure out 4. And traditionally, every plaintiff's case will have these particular interests. Now that we've identified the interest that we've got and what it is that we want, let's now work on the strategy for obtaining those goals. Traditionally, there's two types of negotiation I want to talk about. The first one is called distributive bargaining, and the second is called integrative bargaining. Distributive bargaining is the traditional back and forth haggling that we've all become accustomed to over the years. An example of it is, let's say there's a fixed pie here. It's a particular size. If I'm party 1 and I want a piece of that pie, then in order for me to get that, party number 2 has to get less. If I want a bigger piece of that pie, well, now party 2 gets even less and is more angry. So it's an I win, you lose, or you win and I lose. It's a fixed pie distribution. The other type of negotiation I want to talk to you about is called integrative bargaining, which is interest-based negotiation. Here, in most cases, we'll have, let's say in the traditional bodily injury case, there'll be liability, damages, and causation. They're the primary interest and issues we have to deal with. Those are readily visible. If we're looking at this line here and this little mountain, this is what you can see. It's very visible and it's apparent. However, oftentimes the interests are deeper than that. Sometimes the interests go below the line or below the water, as we sort of have here. Those types of interests might include in a death case or an employment case an apology. It might include some discussion on the uncertainty of what will the client ever recover from the injuries? What will the medical sequelae be? What will be the future costs of the treatment? What are going to be the future, what will be the future treatment? Where will all that take us? Sometimes they want to talk about the impact on their life. They want to talk about the risk of going to trial or the costs of going to trial. These are interests that are below the line. They're not readily apparent, but they have to be identified and discussed in order to sometimes resolve the case and the issues that are above the line. Now that we've identified what it is that we want and the type of bargaining process that we're going to use, we can now proceed and implement that strategy in that negotiation. But one other thing I wanted to point out, we talked about interests that are below the line and above the line. These are obviously the interests in this plaintiff's case that are pretty much above the line. You can also apply the same process and the same thinking to identifying what it is that the client needs and developing their own interests. Where this client may say that the net recovery to the client is objective in dollar nature, but it'll be the basis for how they decided that. And that might have something to do with the subjective interest that they need to talk to you about.